C'est correct. C'est correct. Good afternoon, bonjour everyone. Merci de vous joindre à nous aujourd'hui à l'occasion de cette conférence de presse au sujet de notre nouveau projet de loi C-14, la loi des mesures de réforme concernant la mise en liberté sous caution et la détermination de la peine. On est vraiment excités de vous présenter ce nouveau projet de loi aujourd'hui. Je tiens d'abord à souligner que nous sommes réunis ici sur le territoire traditionnel non cédé de la nation Algonquin, Anishinaabe. I am joined today by the Honourable Minister of Justice and Attorney General Sean Fraser, Jody Boudreau, Deputy Commissioner of the RCMP, and the Honourable Bill Blair, Member of Parliament for Scarborough Southwest. Les Canadiens s'attendent à ce que ce gouvernement agisse de manière décisive pour assurer la sécurité des collectivités et c'est exactement ce que nous faisons. Nous avons été élus sur cette plateforme spécifique et nous avons très hâte de vous présenter ce projet de loi aujourd'hui. Après un été productif et grâce à une étroite collaboration avec les provinces, les territoires et les forces de l'ordre sur le terrain, aujourd'hui, l'honorable Sean Fraser a déposé au Parlement ce nouveau projet de loi C-14 visant à réformer les règles relatives à la mise en liberté sous caution et la détermination de la peine. Canadians can count on us. We are delivering on commitments by taking strong actions to keep violent and repeat offenders off our streets. Our government is assuming a responsible leadership, one where it listens to stakeholders before drafting laws. Nos réformes sont rigoureuses, mais équitables, fondées sur des données probantes et élaborées en collaboration avec les provinces et les territoires qui sont, eux, responsables de l'administration de la preuve. Nous ne visons pas à faire les manchettes. Notre objectif est plutôt de bâtir un Canada plus sûr et plus fort, fondé sur la primauté du droit à travers des actions concrètes. And now, I will now turn this over to Bill Blair. Thank you.
Thank you very much, Patricia, and good afternoon, everyone. I am very honored to be here with the Attorney General and my colleagues for the introduction of a very important piece of legislation, Bill C-14. As many of you, I'm sure, may be aware, I spent decades of my life serving as a police officer in the city of Toronto, having spent it as well 10 years there as the chief of police. And one of the things that I learned is that there is no greater responsibility for any order of government, whether it be federal, provincial, or municipal, than the safety of its citizens. It is a shared responsibility, and it requires the unwavering commitment of all orders of government and all of some very important institutions in this country to keep our citizens safe. I also learned as a police officer in my city that unfortunately there are some individuals who are so dangerous that society must be protected from them, and that we have to ensure that our law enforcement officials, our prosecutors, our judges, our courts, and our corrections facilities have the tools and the authorities that they need in order to keep our communities safe. I firmly believe that there is no greater enemy to public safety than fear, and when our citizens become fearful of living in their own communities, of taking their kids to the park, of shopping on their main street, of engaging with their neighbors, then our communities become less safe. I am particularly honored by this particular bill and the process that our Attorney General and our government has undertaken in order to listen to stakeholders. There has been perhaps an unprecedented collaboration between provinces, Attorney Generals, our Premiers, and our Solicitor Generals. And as a former president of both the Canadian and Ontario Association of Chiefs of Police, I can share with you it has been difficult over past decades to get the ear of government. But in this case, our Attorney General, our Public Safety Minister, this government has been listening. This has been the most collaborative and consultative process that I have ever been exposed to. And in my conversations with my former colleagues, police chiefs and police associations across this country, they are grateful that they have been listened to and that their advocacy is reflected in this legislation. And therefore, it is truly my honor to have the opportunity to stand before you today and to introduce an extraordinary Attorney General, a man who has brought this bill forward. It's going to make a difference for all Canadians, and it's going to help us keep our communities safe. Attorney General Sean Fraser.
Believe it or not, we may have to start with an adjustment of the stand here. So. I think down a touch. And back the other way. A little more. No, back. You had it set there and down. Yeah, there you go. There you go. Thank you so much. Colleagues, thank you so much. Bill, in particular, for your kind introduction. Deputy Commissioner, thank you for being here. And I want to draw specific attention to my Parliamentary Secretary, Ms. Lattanzio, Minister Ananda Sangri, and Minister Sahota as well. It is a real honour and privilege to be here to address our fellow Canadians. Today is about stronger laws and safer communities. This morning, we introduced the Bail and Sentencing Reform Act. This is a package of sweeping reforms that includes more than 80 targeted measures that will make bail laws stricter and sentencing tougher, in particular for violent and repeat offenders. This new law follows extensive consultation with law enforcement, provinces and territories, municipalities, and community partners. Aujourd'hui, on sait à propos des lois plus strictes, des communautés plus chaudes. Nous rendons la mise en liberté sous caution plus difficile et les peines plus sévères. Alors, ces réformes découlent de consultations avec les provinces et territoires et services policiers aussi. Across the country, Canadians are feeling the strain of a justice system that frankly has failed to keep up with what they're feeling and what they're seeing in their communities. I remember the last time the Jays were in the World Series. I was a kid who was playing ball hockey and riding bikes with my friends until we lost daylight. We never worried about our safety, and neither did our parents. The people I talk to today, to the Chief's point, they're afraid, and I understand why. They see repeat offenders coming in and out of the justice system, organized crime that is targeting businesses, and random unprovoked violence in their neighborhoods. It's bad enough that people feel the need to get cameras on their doorsteps, but in some instances they're literally watching them, seeing people break into their homes and steal cars from their driveways. We can't accept this, not in Canada. Today we are changing the law with a stronger focus on public safety. Last week in Alberta, we met as federal, provincial and territorial ministers responsible for both justice and public safety. I want to say thank you to those partners in particular. Although we as the federal government may hold the pen when it comes to changing Canada's criminal laws, it's the provinces who have the responsibility to administer the system. And as part of a team effort, they deserve to be listened to. Many of the reforms that are in this bill are the product of our partnership with provinces and territories and our shared national commitment to keep Canadians safe and restore public confidence in the justice system. Trop de Canadiens sentent que le système ne suit plus la réalité. Trop de gens ont peur et je les comprends. Ce n'est pas acceptable au Canada. La sécurité du public doit toujours passer avant tout. Nous avançons avec les provinces et territoires pour rétablir la confiance et assurer la sécurité publique. This legislation is part of a broader, comprehensive plan that will strengthen public safety right across the country. It rests on three key pillars. First is stronger laws that protect communities and keep dangerous offenders off our streets. Second, it will involve support on the front line, including 1,000 new RCMP, 1,000 new border officers, and better tools for both police and prosecutors. Third, we know that it will take upstream investments aimed at preventing crime in the long term, including specifically affordable and supportive housing, mental health and addictions, and programs for youth who are at risk. Premièrement, des lois plus fermes pour protéger nos communautés. Deuxièmement, plus d'appui aux premières lignes, des meilleurs outils pour la police et les procureurs. Et troisièmement, de la prévention à long terme avec les logements, la santé mentale et le programme jeunesse. Aujourd'hui, nous parlons d'abord des lois plus fortes. Today, we are focused on stronger laws to protect our communities. Let's start with bail. We are going to change the criminal law to ensure that the bail system is not viewed as some get-out-of-jail-free card. We're going to ensure that bail hearings treat public safety as a paramount concern. When risks to the public cannot be managed, offenders will be detained. La mise en liberté sous caution n'est pas un passe-droit. Quand il y a risque, la détention s'impose. We've heard repeatedly from municipalities, from business associations, and provinces that the bail system needs to respond not only to the most violent crime in our society, but also to the highest volume offenders who do not respect the law and are repeatedly released into our communities only to offend again and again. Though these individuals make up a small proportion of our population, they can, in some instances, represent a huge proportion of the criminal activity that we actually witness in our communities. This is eroding public trust in the justice system, and this new law will make it easier for courts to order the most high-volume offenders to be detained. We heard directly from police organizations and from provincial governments in particular that reverse onuses should be introduced at bail for certain serious crimes. In most bail hearings, prosecutors must demonstrate a person should be detained before a court denies them bail. A reverse onus flips that rule, meaning the accused must convince the court that they should be released. Dans certains cas graves, les points de départ sert à la détention. L'accusé devra prouver qu'il ne présente pas des risques pour la sécurité publique. This bill adds new reverse onus provisions for certain serious offenses, including things like home invasion, auto theft, human smuggling and human trafficking, violent extortion, certain instances of assault and sexual assaults, and repeat violent crime with a weapon. We are also imposing a reverse onus on someone who has been convicted of crime and is awaiting sentencing. We have seen, sadly, tragedies play out in this country, including crimes committed by people who have been found guilty but who are not yet incarcerated. Not only will we be clarifying the principle of restraint in this bill, making it clear that the latter principle does not apply in reverse onus scenarios, and adding more offenses that will be subject to reverse onuses, we're also going to ensure that in those reverse onus scenarios, the accused must provide information that clearly demonstrates they do not pose a public safety risk. We're here in Ontario today, and I'd like to extend my gratitude to my counterpart, Attorney General Doug Downey, for his extraordinary level of collaboration in advancing this particular proposal and many other reforms that are included in this legislation. I want to spend a few moments to talk not just about bail, but also about sentencing. We are introducing new aggravating factors that will lead to stiffer penalties for violent and repeat offenders. We've also decided to do the same for crimes committed against first responders, for organized retail theft, and theft that harms essential infrastructure. Donc des peines plus longues pour les récidivistes violents et les attaques contre les premiers intervenants. If you target the people who protect us, the businesses that serve us, or the infrastructure that powers us, you should expect a tougher sentence. Si vous attaquez un policier, volez une voiture et visez nos infrastructures, attendez-vous à une peine plus sévère. We're also going to specify that denunciation and deterrence should play a central role in determining the appropriate sentence for home invasion and auto theft. We wish to send a signal to would-be criminals that we will not tolerate their behavior and that there will be serious consequences for their criminal activity. This bill also restores driving prohibitions for criminal negligence causing death or bodily harm, ensuring that dangerous drivers face consequences and victims' families can see justice done. If your negligence kills or seriously injures someone with a vehicle, we don't think that you should be behind the wheel. Les interdictions de conduire sont rétablies pour négligence criminelle causant des blessures ou la mort. Si votre négligence tue ou blesse gravement, vous ne conduisez pas. This bill ensures real accountability for serious and repeat crime. It will encourage courts to see that someone who commits multiple crimes and receives multiple sentences serves a sentence for each of their crimes. If you're sentenced to 2 years for one crime and 4 for another, we believe that you should serve 6. C'est-à-dire des peines consécutives pour des crimes multiples. 2 ans plus 4 ans, cela fait 6 ans. In addition, we're going to change certain laws from previous governments that we do not believe are working today. Right now, someone who commits sexual assault could end up serving their sentence at home in the same community as their victim. We've heard from victims that that doesn't feel like justice. We will ensure that people who commit sexual assault and sexual crimes against children do not receive house arrest. The justice system is only going to work, though, if we continue to work together. Le système fonctionne seulement si on travaille ensemble. I want to reiterate my thanks to a number of caucus colleagues who are here today, many of whom have engaged in this process and are going to see their advocacy reflected in this bill. It's also important that we work across levels of government, regardless of party. I want to say thanks once again to every provincial and territorial partner who have helped inform our work on these changes to Canada's criminal laws. We need that same spirit of partnership and collaboration when it comes to the implementation of these reforms. Though the federal government is responsible for the text of the criminal code, provinces run the system. We know that they are as committed to public safety as we are, and we look forward to seeing how they will support community policing, prosecution services, bail hearings, provincial courts, detention facilities, and victim services. New Zealand fixe le code criminel, les provinces dirigent l'administration de la justice. We will continue to work closely with every provincial and territorial government to ensure that these reforms that we're advancing today protect Canadians in the real world once the laws are adopted. To close, I just want to say that this is the Bail and Sentencing Reform Act. It involves stricter bail and tougher sentences. It is about safer homes, safer streets, and safer communities. To the Canadians who want to see the government take control of our criminal laws, we have listened to you. Les Canadiens veulent des communautés sûres. Nous les avons écoutés. We have listened to you, and we've listened to partners who know what they are talking about because they work in the system. These reforms are one piece to the puzzle. They build on laws that we have already introduced in this sitting to strengthen our borders and to address hate crimes in this country. And we aren't done yet. We will soon be introducing yet another criminal law to address intimate partner violence, sexual crime, exploitation of kids, the rights of victims, and delays in the criminal justice system. Canadians deserve to feel safe in their homes and in their communities. These new criminal laws will help bring us closer to that reality. Thank you so much. Merci tout le monde.
Thank you. We'll open it to questions now. Please state your name, outlet, one question, one follow-up.
Rémi Autier, CPAC. On a appris d'un représentant du gouvernement ce matin qu'il n'y a aucune étude, aucune évaluation de l'effet qu'auraient ces changements sur la population en prison, sur le nombre de personnes et la pression qu'il y a sur les prisons. Pourquoi adopter cette législation-là si on ne sait pas quel impact ça va avoir sur les prisons provinciales, sur les partenaires?
Justement, c'est difficile d'entendre avec le trafic. I just may need assistance with the translation because of the noise.
So he's basically saying we have no facts, no evidence about people that are being incarcerated. So how are we coming up with this law with no facts?
OK, merci pour la question. Il est très important de recogniser les processus nous utilisons pour créer des nouveaux projets de loi. En particulier, nous avons beaucoup de discussions avec des policiers qui travaillent dans le système de justice chaque jour, qui observent les problèmes dans le système de justice. Au même temps, nous avons beaucoup de discussions avec des provinces et territoires pour comprendre les points de pression dans le système de justice. Quand des partenaires qui gestionnent le système, qui travaillent dans le système, identifier des problèmes, il est très important pour le gouvernement, un partenaire très important pour changer les lois, pour réfléchir les perspectives de nos partenaires. We want to continue to work with those who work in the system, who know it best. We have engaged with stakeholders from a number of different backgrounds, but we've heard nearly unanimously that provinces, territories, and law enforcement have been demanding certain changes that will make their jobs easier to help keep communities safe. We're going to continue to engage with those who are tasked with keeping communities safe and take their feedback as we adopt new laws in Canada.
Et puis, le projet de loi ne comporte pas d'argent pour les provinces pour qu'elles puissent construire des prisons, pour qu'elles puissent répondre à la pression, la plus grande pression qu'il va y avoir sur le système de justice. Est-ce que vous prévoyez faire des transferts ou des investissements justement afin de construire des prisons ou améliorer le système de justice?
Le projet de loi aujourd'hui est juste sur les deux enjeux. Le système de mise en jeu sur liberté, mise en liberté sous caution et de renforcer les pénalités pour les criminels. Il y a beaucoup de discussions sur les besoins du système de justice. Il y a beaucoup de conversations juste la semaine passée avec mes homologues partout notre pays pour discuter la façon pour le gouvernement de collaborer dans l'avenir pour réaliser le changement en réalité. Aujourd'hui, nous changeons les lois dans le code criminel. Demain, nous avons besoin de continuer des conversations avec des partenaires qui gestionnent le système. OK, merci.
Bonjour, Sandrine Vieira du Devoir. Monsieur Fraser, si le projet devient loi, pouvez-vous nous dire combien d'accusés de plus vont rester derrière les barreaux en entendant leur procès? Avez-vous un chiffre? Et est-ce qu'il y a assez de place dans les prisons pour ça en ce moment?
Juste
With this new law, how can you assure them that there's going to be more people behind bars, and how do you have enough places?
OK. Premièrement, il est essentiel de comprendre les rôles pour le gouvernement fédéral et les rôles pour les provinces et territoires. C'est important pour le gouvernement fédéral de changer les codes criminels. C'est pour les provinces et territoires de gestion l'administration de justice dans leur province. Quand les personnes, les gouvernements qui gestionnent le système de justice me disent nous avons besoin de changer de loi, c'est OK pour moi de considérer les proposals et prendre d'action. Mais en même temps, il est essentiel, si les provinces posaient des questions pour changer les lois fédérales, les provinces ajoutaient les ressources nécessaires pour l'administration de justice. I just want to make sure that I understand your question.
No, the question is how many people are going to stay behind bars longer?
It's difficult to predict with certainty what actions may take place in the future. What we're hoping to do is to say when certain criminal behaviors take place, we believe that people will face a tougher time getting bail for the offenses that we've listed, as well as stronger penalties for certain kinds of criminal activity. The projection on the number of people who will face those sentences will depend on what activities may take in the future, and you'll appreciate that may be impossible to predict. But what we can say with some confidence is when those activities take place in our communities, having the rules changed, we know that the process will consider those behaviors differently, and as a result, we expect to see more dangerous people incarcerated as a result of their behavior.
Bonjour, Mylène Crête de La Presse. I'll ask my question in English as well, since there's a bit of trouble with the noise. What are you going to do if the jails cannot absorb more people within their walls?
So one thing that's really important to understand is a lot of the changes that we've asked for, though we agree with them, came directly through conversations with provinces who actually have the responsibility to manage these systems. If the provinces are asking us to change the law, knowing that they have the responsibility for detention facilities when people are being held on bail, they should be asking those questions with full expectation that they're going to develop the capacity to manage the volume of people that will be going through provincial detention facilities. Without exception, we have had provincial governments not only support some of these changes, but in many instances provoke them through asking that the federal government take action in the first instance. We're going to continue to work with provinces. We had very productive conversations last week. And to be clear, we don't have any interest in pointing fingers. We think that they get this. They want to help solve this problem. They know that one element is changing the federal laws. They know other elements involve increased resources at a provincial level. We're going to continue to work with them to better share information as between jurisdictions, to help establish best practices where that may be appropriate. But the provinces who are asking for these changes fully understand that they have a role to play, including, where appropriate, adding more resources to the system, not just when it comes to detention, but making sure we have enough prosecutors, enough provincial court judges, enough community policing to prevent crime from taking place in the first place. This is a collaborative effort. It's going to have to remain that way through the implementation phase of these changes.
My second question is about, do you think that what you're proposing today would have prevented, for instance, the murder of Gaby Renault in Quebec, or even the one that occurred recently in Brampton, Ontario?
Look, I think it's it can be a difficult and unhelpful exercise to predict what specific actions may have taken place or may have not taken place. We do know, though, that when you look not just at the changes to criminal laws, but take a more holistic approach about ensuring we have stronger laws to deter criminal behavior, ensuring that we have more resources for those on the front line to prevent crime in the first place and investigate it on the back end, and importantly, make the upstream investments to help direct people away from a criminal lifestyle, that over time, the combined impact of those policies will reduce crime levels overall. Whether it will change the facts on an individual scenario is very difficult. I would suggest impossible to predict. But we do know that we have to make these investments at large scale in collaboration with provinces and territories so that fewer people, fewer communities see tragedies play out in their own backyards. So I do believe it's going to have an impact going forward, but I believe it's impossible to say with certainty what laws may have had an impact when you look in the rearview mirror.
Hey, Minister Fraser, Marco Vigliati, iPolitics. I'm going to go on the same thread of some of my colleagues about these changes and the impact on areas of provincial jurisdiction. I understand that you're saying, look, we did the criminal code changes that we own, and you guys, it's up to you in terms of the administration of justice. But I know one of your predecessors, R.F. Varani, also took the Ontario government to task, for example, about the number of crown prosecutors available to contest bail hearings. And we also know that jail conditions are considered a factor when it comes to assessing applications for bail or also at the sentencing time. So do you feel like there is enough kind of groundwork being done at that provincial level that we're not going to be in a situation where we're going to be back to where we were after the Jordan decision, the court backlogs are going to worsen, and people are going to be released as bail as a result? Like, do you feel confident the provinces have done their homework to allow these changes to have effect?
So let me start just by saying I really sincerely believe that provinces understand the nature of the problem and want to take action to address the problem. They want to make sure that we do our part. We want to make sure that they do their part. And everybody is very open about who owns which part of the system in this conversation. When you do make changes to the laws, it can have an impact, obviously, on the administration of justice that considers those particular laws. This is something that I've thought very deeply about over the past few months. And my perspective is, when you're setting the rules, you have to set the rules that are going to keep people safe. That has to be your paramount concern. We believe that we've done that with the bill that we have presented today. The provinces have been asking for a lot of the changes that are actually embedded in the bill that we have now tabled in Parliament. They did that with full knowledge that there will be resource implications for the administrative requirements of the system. That'll involve community policing. It will involve detention facilities. It will involve provincial courts. There's going to be continued conversations about where we can be a good partner, but there's also going to be a real responsibility that's required for every level of government to take. After the conversation I had last week in Alberta with our provincial counterparts, not just on justice, but on public safety as well, we discussed at length how we can work together to actually implement reforms more broadly that will improve community safety. Everybody is singing from the same songbook. I'd say we're all in tune right now. Time will tell whether the changes we're making today will be met with resources at the provincial level, but we're going to be continuing that conversation, not just in the days that follow this announcement, but over the next number of months and years to ensure that the changes we're making today are actually felt as progress for people and communities.
And I just wanted to ask about the youth criminal justice changes. Is it fair to say that the amendment that is being proposed in this bill will mean more young people will be serving time behind bars for violent offenses? And if so, does this represent an effort by this government to kind of walk away some of that core tenet of that piece of legislation, that is, custodial sentences should be reserved from the most extreme cases possible and might hurt the rehabilitation of young people?
We made efforts to clarify for the courts that will apply the Youth Criminal Justice Act that there is a broader range of offences that are violent and could cause bodily harm that could justify a custodial sentence. We've also made certain changes about the records that law enforcement can keep to understand the history of a young offender that may not have actually led to charges in the past. This is a recognition that there are very real challenges in our system, but we want to mirror some of the changes we're making today with those upstream investments that pull more at-risk youth away from the criminal justice system to begin with before crime takes place. There are other areas that I wish to explore in collaboration with parliamentary colleagues that came later in the process of consultation, in particular around the recruitment of young people by criminal organizations. And this is excellent fodder for future action that we may be able to collaborate with provinces on. But to answer your question, this was about providing clarity to courts about which offences we consider violent to ensure that the courts apply the law as we intended.
Hi, Minister Fraser. Gillian Piper with Global News. Statistics Canada told Global News that they don't collect data on the number of offences committed by those out on bail at the time of their offence. So what data are you relying on to suggest reverse onus will make Canada safer?
So we have been listening to a number of different stakeholders in the development of this legislation. When we're talking about these very high volume offenders, we are responding to requests that came from municipal governments across Canada, from business associations, from downtown associations, and from provincial governments who have indicated very real problems where sometimes in communities individual offenders are known by name for the frequency with which they commit criminal offences. The Stats Canada point that you made is well taken. However, when it comes to the management of bail and the data collection of the bail system, there's obviously a role for provinces to play as well. The ability of the court to actually enforce some of these rules will depend on a change in practices in some circumstances of the province's need to collect data about what kind of offences are going through the bail system and are actually leading to a bail decision in one direction or another. Some of these processes are not designed necessarily only to have an impact today, but are going to be in place for a significant number of years, we expect. And we fully appreciate that provinces will need some time to ramp up some of the data collection efforts. And I've had conversations with many of my counterparts, and they seemingly recognize the need to have better data to ensure that decisions that are being made by their bail courts are informed by facts and by evidence. So this is going to be an ongoing process that I expect will improve over time. But the regularity with which we heard this concern from partners who have something important to say demanded that we take action.
Hi, Minister. Mark Ramsey with the Toronto Star. We're heading towards a budget where nearly all departments are expected to make some pretty steep cuts. Are you confident that none of the cuts that are going to come from the Justice Department or Correctional Services Canada are going to undermine the changes that you're trying to make today?
Look, we, like every other government department, are responding to the very real need to ensure that we are spending public resources in a responsible way. We don't want to have the decisions that we make impact the public safety of Canadians. We've worked to ensure that we can continue to offer the programs that we believe are having the maximum impact for people who interface with the justice system, and importantly, to reduce in many instances the number of instances during which a person has an interface with the criminal justice system. That's a long way of answering your question, which is essentially, yes, we're confident that the decisions that we're taking, not just as part of the comprehensive expenditures review, but more broadly across government, are designed to enhance public safety, not work against the policies that we're making.
Hi, Olivier Ferron-Boissé de TVA. We've heard calls for your government to remove the principle of restraint. You've chosen not to do it. Instead, you're proposing to direct police and courts on how to apply the principle of restraint. It seems a bit weak. How is that going to ensure that people that should probably be not out on bail are not out on bail?
So a couple of things in response. First, you'll see the reaction of the Canadian Police Association and the Canadian Association of Chiefs of Police, who are endorsing publicly this bill. They believe it's going to promote public safety, and even Ontario's Premier Doug Ford has indicated his support publicly for the direction of this bill. So the only people, frankly, that I've seen criticize the way we've dealt with the principle of restraint are those who have a political interest represented in the House of Commons of undermining the good work that is supported by Conservative provincial governments and by police associations nationally. To answer your question not on the politics but on the substance, the principle of restraint didn't come from government legislation. It came from the Supreme Court of Canada. There were changes that were implemented to the criminal code that reflected a codification of that test. But we have heard on a number of instances that the codification of the principle of restraint may have led to its misapplication in certain circumstances. We are introducing changes to the criminal code that fundamentally shifts how the principle of restraint is dealt with in the text of the criminal code. Specifically, we are making it very clear that this is not a justification for automatic release. We are specifically saying that if you cannot manage the public safety imperative when it comes to someone who's facing a bail decision, then you have to detain that person. And if you make a decision to release that person, you must be satisfied that the grounds for detention are satisfied, specifically public safety, but also the public faith in the administration of justice. So any suggestion that a law is weak when the actual impact is to say you must detain a person if you can't manage the public safety interest is not informed by an honest reading of the text of the legislation, but perhaps a political perspective that may speak to someone's interest in this conversation.
Peter Mazaru with the Hill Times. We know how reverse onus hearings work. The onus of proof shifts, but what makes you confident that that's going to result in more people being detained?
So the goal is not to simply detain more people. It's to detain dangerous people who pose a risk to public safety. There are certain changes that we made to reverse onuses that is informed by those who work within the system and those who manage the system, in particular provincial governments. And I do again want to re-emphasize the role of my Ontario counterpart, Doug Downey, on this very specific question. In addition to the reverse onuses that we've campaigned on as part of the last federal election, through our conversations, not just with Ontario, but other provinces as well, we've seen that there are other measures we can take that will change the way that these conversations play out in a court. It's not simply going to be that an accused person goes first as opposed to the Crown. There will be an obligation upon that accused person to present credible information that clearly demonstrates why they should be released and that it will not have an impact on public safety. Clarifying as well that the latter principle will not apply in circumstances where a reverse onus is in effect will also fundamentally change the considerations that a court will determine. Whether there are more people detained or not will depend as much on whether we have law enforcement who are charging people with crimes as it will the rules that take place. But what we're saying right now is when a person comes to court and faces a reverse onus, that process is going to shift that will put a higher obligation on a person to demonstrate why they ought to be released.
And you've sort of packaged certain offenses together, I think, when it comes to consecutive sentencing, like break and enter and auto theft. Can you explain how that's going to work?
Yeah, so the consecutive sentencing regime that we're including in this bill, you will understand this, but for the benefit of those who may be listening in, oftentimes when a person receives multiple sentences, they will serve the shorter of those sentences during the term of the longer sentence. What we're saying, though we maintain respect for the totality principle and the discretion of the courts to do their job that we trust them to do, that we do wish to see when there are multiple crimes committed, each of which carries an independent sentence, that we would like the offender to be held responsible for each of those offenses. We do see that concurrent sentences can have the impact of having a person serve less time than their behavior would warrant if you actually read the text of the code. So our goal here is to look at an offender who may commit multiple offenses, which you often do see with home invasions and auto theft, and have those sentences stack rather than be served at the same time.
Good afternoon, Minister. Christopher Nardi from the National Post. As you know, multiple provincial federally appointed courts, so trial mostly, have put in requests for you to increase their judicial complement, not just fill vacancies, but increase the complement because of the tremendous amount of cases that they have coming down the pipeline. In the budget coming up, do you have plans to increase the overall judicial complements across the country? And what are your views on the recommendation by the Judicial Compensation Commission suggesting a $28,000 increase for judicial compensation?
Look, thanks very much for the question. Though I'll get to judicial complement in a second, I do want to make sure that people understand the difference between the vacancies and complement. We did have challenges previously with a significant number of vacancies where a position existed on paper but didn't have a person sitting in the seat in the real world. That project has largely been, problem has largely been addressed through the work of my predecessor, Minister Varani, who largely filled almost every vacancy that existed at the time that he held this portfolio. That work has continued, and we intend to keep up on the vacancies that do exist. You rightly pointed out, we've received calls to increase the judicial complement, meaning for not your benefit, for the public, that there may be a need for additional positions on the bench beyond the vacancies that have now been filled. That's part of an exercise that happens on an ongoing basis. I don't want to speak to what may or may not be in the upcoming federal budget, but we're currently assessing the validity of the asks that we've received to ensure that we agree. When we complete that exercise, and the answer will vary between province and province, we will come to a conclusion, and I respectfully believe I owe an answer first to our provincial counterparts who've made the ask before we address a conclusion publicly. On the response to the Quadrennial Commission, we have an obligation within a matter of weeks to offer a response. We will be releasing that in due course formally in accordance with the timelines, but it will only be a few weeks before our response is made public. So I beg patience of you. It won't be long to wait for your answer.
Good afternoon, Minister. Justin Ling, freelance. One of the driving reasons why so many people are being released on bail, perhaps they shouldn't be, and in some cases be having their charges stayed, is because of court delays. Over the past decade, these court delays have worsened and worsened. The solutions put in place by your government haven't really worked in the grand sense. do you not worry that the reverse onus changes could actually increase complexity for the courts, worsen those delays? And why is there nothing in this package to try and streamline these cases so that people are facing a judge and a jury sooner than 3, 4, or 5 years?
Look, thank you. That's a very important question. And as I indicated very briefly near the end of my remarks, we have another piece of criminal law reform that is going to be introduced in the House of Commons before the House rises for Christmas. That will include a significant component that addresses specifically the Jordan decision and delays that we see in our court systems. We have been working with those who operate within the justice system to understand where the delays exist and what remedies we may introduce that will help alleviate them. Certainly, part of that conversation is whether we have an appropriate judicial complement to hear cases and move them forward quickly. Some of that has to do with the lengthy process of introducing evidence, in particular in sexual assault trials. Other challenges we have actually precede court delays, but have to do with the extraordinary burden that police forces manage when it comes to collecting, detaining, and considering evidence before they lay charges. We intend to address many of those aspects and more in a bill that will be tabled this fall before the House rises. In addition, we are aware that there is a downstream impact of the rules that we put in place, but that's not an excuse to have laws that would do something less than keep communities safe. The starting point in this conversation, and my own philosophy that has informed this particular perspective, is that we need to understand what laws we believe will keep people safe. We want to start by establishing a set of rules that will have that impact. Then we want to work with the levels of government that manage the system locally, often provinces and territories, to ensure that they're matching the rules that they're asking for with the resources that will help manage the system. But this is not an attempt to point fingers or lay blame to another level of government. It's a signal of extraordinary collaboration. In my 10 years as a member of Parliament, I've never seen so many provinces so eager and willing to help inform the work of the federal government. And for my own part, I have never engaged so much with my provincial counterparts to ensure that the measures that we're putting reflect their perspective, but having very open conversations about what that will mean on the back end. This is going to be a continuing exercise in collaboration and engagement across levels of government, but my hope is we're going to start with rules that will do a better job of keeping people safe and work with good faith partners at other levels of government to properly resource their systems as we do the same federally.
Hi, Paula Tran from the Ottawa Citizen. You talked a lot about consultations with police and provinces and territories, but have you consulted with community groups, especially those that represent, Indigenous communities and communities of color?
So we've had a number of different groups within Canada that took part in engagement before we introduced this bill. We absolutely have engaged with civil society stakeholders. We've engaged with Indigenous partners. We've engaged with those who represent other racialized communities. And we've engaged more broadly with advocates from civil society to understand the impact. There seems to be an appreciation in many instances, and it's important to understand as well, civil society or the stakeholders that you've mentioned or the Indigenous governments you mentioned are not monolithic, and they don't necessarily all share identical perspectives. We've done our best to listen to the range of perspectives that we've heard and tried to focus on the areas where there is common ground. There are going to be continuing conversations as we manage the bail system and sentencing regime on the back end of this legislation that will work to accommodate. But to answer your question, we did a broad-based engagement that included some of the groups you've referenced.
There are currently a lot of people in jail who have been denied bail, but later found not guilty for their crimes. So how can you ensure that these people don't spend too much time in jail under the new provisions that are being proposed here?
So this builds on my response to Mr. Ling. It's very important that we have access to speedy trials. Justice delayed can be justice denied. And people who have not committed a crime should not be incarcerated. The focus of this particular legislation is to deal with people who the system will identify as presenting a great risk to public safety. We do need to work with other levels of government, again, with provinces and territories, to ensure that there's sufficient resources in the system to have people get their day in court. If they disagree with the offense that they've been charged with, they should be given an early opportunity to make their case and to have a judge or justice of the peace determine the outcome of their bail bail hearing or potentially their sentencing, as the case may be. But the short answer to your question is that it's going to take continued collaboration and investment by respective levels of government in their areas of jurisdiction to ensure that we have rules that are in place to protect the public, but resources that are behind those rules to ensure people have a timely access to having their case heard.
David Thornton, CBC. One of your officials, Minister, called the changes to the criminal code that you're proposing today a calibration of previous changes that previous governments have made. Obviously, the previous Liberal government made changes to the criminal code, to bail reform, to sentencing. And so you served as a minister in that government. Did you all go too far in those changes?
So some of the changes that we put in place remain in effect today, and I remain supportive of today. There are others that we've heard through our extensive engagement with people in the justice system that we think we should change after this engagement and after having the benefit of having different rules in place. I look to the principle of restraint. We have made a significant change to clarify that this is not meant to justify an automatic release, but instead demands that the decision maker be satisfied a person will not pose a threat to public safety. That is a significant change in the text of the criminal code that we expect will have an impact in its application. Similarly, when it comes to conditional sentencing orders, we made certain changes a few years ago under the previous government that we've heard from communities saying that we think you need to revisit some of these conversations. Ensuring that house arrest doesn't apply to serious cases of sexual assault or sexual crimes against children is a kind of change that recognizes that when you've done something and you've not hit the mark, you have to change it. It's irresponsible as a government and as an individual to insist that you've always been right about everything. There are people who operate in politics that way, and I think it's a dangerous perspective. We have the opportunity to continue to engage with Canadians as to what direction they think their criminal laws should take, and we're going to respond as we have an opportunity to see how these things play out in practice.
Good afternoon, Minister Fraser. David Baxter with the Canadian Press. Just since the legislation has come out, we've heard from defense attorneys and civil liberties associations saying that without concrete data on how many offenders who are on bail are reoffending, that these bail provisions don't stand up to the charter right for reasonable bail. Without having that concrete data, as you've mentioned, how do you defend these new policies ahead of potential charter challenges?
So my focus right now is to adopt laws that we believe are going to help keep Canadians safe. That is the overarching principle that we've taken when it comes to this conversation. We didn't sit behind closed doors on Parliament Hill and dream up what might have that impact. We talked to people whose job it is to keep Canadians safe. You'll notice statements of support that have come from law enforcement, statements of support that have come from provincial governments. We'll work with others to ensure that we protect the rights of Canadians, and we think we've done that through the way in which we've advanced some of the proposals that you've shared commentary on with me just now. But my own perspective here is that you don't have to choose between public safety and your Constitution. You operate within your Constitution to advance the rules that you think are going to promote public safety. And my view is that's what we've done with this bill. On the point about data, we have obviously relied upon the experience of law enforcement and provincial governments who administer the system, but we know there is more work to do that's going to further improve the system as we pursue data collection with these measures in place, and frankly with the system that pre-existed the measures we've introduced today. That's going to involve continued collaboration with provinces and territories who are often closer to the ground, particularly when it comes to bail hearings, to understand why a person is getting released in a disaggregated way, why people are being released on what charges and what impact that's going to have on public safety. That's going to be a big part of the work that we do in the months ahead to understand whether the rules we're putting in place today have the intended impact.
Thanks. Fraser Needham, APTN News. One thing the data does show is that Indigenous people are grossly overrepresented in our prison system. Are you not concerned that legislation like this will just lead to more Indigenous people behind bars?
This is a very real concern, overrepresentation within the justice system, certainly of Indigenous peoples, of other racialized communities as well. Again, we started with the idea that we wanted to have the rules in place that would help protect public safety. We want to work with those who administer the system to ensure that it does it in a way that does not exacerbate problems that exist within the system that do have a disproportionate impact on Indigenous peoples and on other communities. I've had a number of conversations in recent weeks in particular about the importance of implementing the Indigenous justice strategy, on working not just with provinces and territories but with Indigenous governments to understand how we can have enhanced community policing, enforcement of Indigenous laws that are adopted by communities, and relying on solutions that are advanced by individual First Nations, Inuit, and Métis communities more broadly. This is going to be an ongoing body of work that will require continued participation. But when we seek to adopt laws that will impact the public safety, we need to make sure the implementation that follows recognizes the unique impact it can have on a range of different and disparate communities. The work that we want to do to protect against overrepresentation is a major part of the Indigenous justice strategy and the Black justice strategy, and that work's going to continue on an ongoing basis to ensure that we can help address some of the challenges that you've referenced.
Last question.
James Taves, private citizen. Since both crime rates and recidivism are consistently on a decline, that indicates that the very real fear that exists is a matter of perception and not reality. Is it not part of your task to assure that Canadians are reminded of that, so we are not acting out of needless fear, but out of an important continuing adjustment of the legal system, alongside of the recognition that we live in a very safe society that has been created over numerous governments, and that trajectory is one you're taking on. Thank you for the question and opportunity.
Yeah, no, thank you, and I welcome your participation in this this conversation. So crime rates have come down in the last year that we have data. But whether you can say they've come down consistently depends on when you start measuring that.
The 1960s.
Sorry, I couldn't.
Since the 1960s, it is not a periodic decline. It's a long-term decline. The messaging to the citizenry that we are protecting you is a very politically astute one, but I would say dishonest. And I would ask governments to honestly reflect on reality alongside of going and correcting and tweaking the systems more effectively.
So, look, thank you. So, look, I maintain the point that where you start measuring has an impact on how you interpret the data. The last year that we have on record, we have seen crime come down, violent crime come down. That is a good thing, unquestionably a good thing. In the number of years that preceded, we've actually seen crime rising and violent crime continuing to be a problem. We've also seen that your experience in this conversation depends very much where you are in the country. There are communities who have seen significant increases in home invasions and auto theft, and we believe we need to respond. Though there are other communities that may not have the same level of challenge, that doesn't mean we shouldn't respond to a very real and pressing problem that other regions within this federation are raising with us. But we do need to take a long-term view and be honest with Canadians about what's happening with public safety and crime. That's why, in addition to adopting these stronger laws that will be oriented around public safety, we're also talking about making sure we have sufficient resources to the RCMP and border officials to deal with challenges that they're facing. And we recognize the need to make upstream investments in things like affordable and supportive housing, and things like mental health and addictions, and things like programming for young people who are at risk. Over time, I believe we can see that trend continuing with more consistency in a downward way, despite the fact it may be lower today than in some places in Canada's history. Crime is higher today than it was 5 years ago. So to the extent that we can have that a downward trend apply year after year after year, and believe that criminal laws can be part of it, I think that's a conversation we should be very open with about Canadians. Yeah.
Thank you.
Yeah,
This
thank you for the
concludes the
question.
press conference. Thank you very much.
Thank you, everyone. Merci tout le monde.
You need some water.
Yeah, that's good.